So they handed me this presentation as I walked in the door, so hopefully this goes well. Today I'm going to talk to you about experts, spoliation, and sanctions, any one of which goes wrong in your case and is going to ruin your entire day. All three of which go wrong at the same time, and it will devastate your case no matter where you are on the merits. Now, the presentation I'm going to give to you today is going to be broken down into three parts. We have, to start off just with the framework we're working in, 3.4 under the New York Bar rules as well as the ABA rules, and how the rules of federal procedure and your local civil rules reinforce that Rule 3.4. And then I'm going to give you an overview of a case that I've worked on for the last couple of years, the Oso Landslide. I don't know if that rings a bell with anyone, but it was a gigantic landslide in 2014, one of the largest landslides in history, certainly one of the most deadly. It was a 600-foot tall hill that gave way at 60 miles an hour and produced a two-story flood of mud that wiped across an entire valley by a mile, wiped out an entire community that was at the bottom of the hillside, killed 43 people, and injured dozens of others. Now, the particular thing I'm going to talk about in this case is one of the defendants in that case was the state of Washington, and how the state of Washington handled its expert discovery, or rather how it mishandled it, in such a way that the court issued an order that found that the state AG's office badly misunderstood their obligations under the federal discovery rules, that they had displayed a level of institutional arrogance in the way that they actually did apply the rules they thought applied, and then issued a $1.2 million sanction against them, ordered that they have an educational program put in to teach assistant attorney generals how to actually conduct expert discovery, and put in an adverse inference in the case that would be read to the jury at the beginning of the case, as well as after every expert testified about the fact that they had deleted all of their emails and all of the evidence that they had collected along the way. And then finally, I'm going to give you some lessons learned to take away. So 3.4, that's where we're going to start with. 3.4 really has two parts that are relevant for our purposes. The first is Section A here, which is really, aside from your obligations under the FRCP or your local state rules, you have an independent ethical obligation to not delete, alter, or conceal documents or any other evidence. And for our purposes, for experts, the last clause on this is important. A lawyer shall not counsel or assist another person to do those same things. So not only can you not do that, you can't knowingly sit by and let your experts do it either. The second part of 3.4 that's important for our purposes is Part D, which says that not only do you have this independent ethical obligation, you have an ethical obligation to follow the civil rules. And to be able to do that, if you can take one thing away from this case, to be able to follow your ethical responsibility, you need to understand the rules that apply to your case and understand in your particular situation, if you're doing something new, you're doing something tricky. As Joe was talking about, it's not the intentional thing that gets you in trouble. It's the thing you didn't think about. It's the thing that you do sort of in haste. As you can see, New York RPC is essentially the same, but it hits even harder on the fact that your ethical obligations stem out of the fact that you have legal obligations under the civil rules. And then spoliation, for anybody that hasn't had spoliation come up in your practice, you live charmed lives. I envy you greatly. But the whole idea is that you can't destroy evidence that might be useful for somebody, for the other side in your litigation. Now, all of this backstops into the federal rules or the state civil rules that you're operating under. And if you follow the rules, you're most likely going to meet your ethical obligations under RPC 3.4. But if you don't follow the rules, not only are you looking at some sort of ethical investigation from your local bar association, you're looking at actual tangible impacts to your case that you're in, either adverse inferences, potentially default, or even dismissal, depending on which side you're on. And all of this seems obvious. I hope everyone in this room thinks, well, of course I'm not going to delete evidence. Of course I'm not going to conceal it. That's what bad attorneys do. But I'm going to tell you a story about the Oso Landslide. And the defense of that case and how good attorneys ended up doing something very, very bad. So you can see here the Oso landslide, just for scale. That entire debris field is a mile long. Where the main clump of debris is, where the river should be, is where the community was and where 43 people ended up losing their lives. The main question in this case, as to the state at least, there were multiple defendants and multiple plaintiffs groups. But as to the state, the question was, they were a landowner. They owned a good portion of the landslide, and they also owned sort of the toe of the landslide along the river because they had aquarian rights. And the question for the state was, they felt that they could get out if they could just prove they didn't cause the landslide. If we didn't cause the landslide, we have no liability as a landowner, and therefore we're out. The way they wanted to prove that was to put together this interdisciplinary team of 7 experts, hydromorphologists, geologists, you name it, when it comes to water plus dirt. And these people were located across the country, and they wanted them to prepare one single joint report coming to the conclusion that the state did not cause the landslide. And this is the moment that the state really made the mistake of not really thinking through what they were doing. Interdisciplinary single reports are not common. Usually you have one expert that does one report, you have another expert that does another report. What you don't usually have is a bunch of experts getting together and making one single opinion. And what they didn't think through was these experts were gonna have to talk a lot. They were gonna have to email each other, they were gonna have to send reports back and forth to each other, not involving attorneys, not involving impressions of what the attorneys wanted in the case, but really just scientific data. And what they didn't think about was that the federal rules of discovery, whether you're talking about pre-2010 amendments or after 2010, always required expert-to-expert communications to be produced. But what they thought about it in terms of is what the federal rules don't require. They don't require draft reports, and they don't require communications between attorneys. And the internal emails that eventually came out from the AG's office, they thought that because all of this was leading up to some sort of final report, that everything that the experts were talking to about ended up being draft reports of some sort. And if they weren't draft reports, then they were communications with attorneys. Sure, attorneys may not always be on it, but they were at the direction of attorneys, so they would be privileged in some way and wouldn't have to be turned over. Unfortunately for them and that interpretation, we also had a protocol in place between all the plaintiffs and the defendants that instead of issuing subpoenas to all of the experts, we would agree to a protocol where 14 days before a deposition, you would turn over certain categories of documents, and if you see the last item there is communications between experts and any other experts in the case. And as we went along, there weren't very many emails that were being turned over by the state, which honestly didn't strike anybody as abnormal. Usually you tell your experts don't write anything down, then it can't be discovered. And so the thought was from everyone involved that that was probably what was happening. But as somewhere along the way, one of the experts produced a folder called communications, and it was empty. And that seemed curious. And so he was asked about that at his deposition, and his response was, oh, it's empty because I deleted all of my emails. As they went along, not only did I delete all of my emails, we agreed as an expert group at the beginning of the case that we were going to delete all of our emails as it went along. And didn't you guys get, in the communication folder, I didn't include any emails, but I included an explanation of all of this. Did you guys not get that? We did not get that. And the answer was that the state had stripped it out of the communications folder, realizing that they had a problem, that they were deleting emails that were supposed to be disclosed, that they were withholding things that they shouldn't have disclosed, all of this from later turned over internal emails that we found out. And this was sort of the start of the cover-up, which is never a good thing. And this is the text file that was supposed to be in that folder, which reads, at the onset of the case, the Washington experts instituted a policy of deleting any email communications, and then at the end, all draft materials were discarded upon finalization of our preliminary and interim expert reports. So not only did they delete all of their emails along the way, after they made their final decision, they deleted everything that could have countered that decision. Anything that they did not specifically rely on and did not support their opinion, they just deleted. Around the same time, as part of the cover-up, they started asking the experts to CC them on all of the emails that they were sending amongst themselves. Yeah, we're probably going to get in trouble for the fact that we deleted a bunch of emails, but let's make sure we have a protection of attorney-client privilege by CCing everything going forward. And so from that point on, it was really just about the development of the spoliation case and how this was actually going to impact the case. This gives you just a little bit of overview of how many emails had actually been produced by the time all of this came about. Not very many emails at all, and some experts hadn't produced any emails at all. So what happened was there needed to be some development of a timeline and an easy understand package for the judge to be able to understand just what the state had done over the last several years. Now, this timeline is just an example of the first page of a 6-page timeline that really the whole takeaway was the fact that the state understood, or at least was well aware of and discussed the fact that these communications probably were discoverable, that they probably should have turned them over, and that they're not really sure what to do about it. Like I said, here's some of the categories of state expert materials that they deleted and withheld. Communications between experts, they withheld or deleted all of those. Information and data that was developed by those experts when they were consulting experts, but then moved over to testifying experts, they withheld all of that as well. And then really everything else they sort of put into the drafts folder. It's a draft, we don't have to worry about it. And then finally, as I said, they started CCing attorneys on everything they did. So when the judge got a hold of this, he ordered the internal review of AG emails and ended up releasing the ones that he relied upon when he issued his sanctions order, which showed that about 6 months before the plaintiffs had actually discovered this, that the state AG's attorneys were aware of the fact that this was a problem, but they kept going with it anyway. Mostly because they were afraid of what the outcome would be if they came forward. The judge also ended up ordering the forensic recovery of deleted emails, which turned out not to be possible because of the time length that had happened between the time that they had been deleted and when it actually came before the court. There were some emails that were recovered, but ultimately what the testimony was is there was no way to know how many emails had not been recovered, how many documents had not been recovered. So ultimately what the court ordered was all of the attorney's fees for the sanctions motion, which was about $300,000, $400,000, and then trebled that for monetary punishment, ended up with about a $1.2 million sanctions order. And at the same time, like I said, actually ordered them to institute an educational program to teach their assistant attorney generals how to actually do their job and to actually do discovery under the federal rules of civil procedure. And they also issued an adverse jury instruction, which you can read if you like, but basically says that the jury can assume that all of those missing documents were bad for the state and good for the plaintiffs. For our purposes, this is really the key slide. Why did the court find that this happened? He ultimately did not find any bad faith. He said that the plaintiffs overstepped a tad in trying to paint it as bad faith, that the internal emails were more about just a complete misunderstanding of what their responsibilities were under the federal rules of civil procedure. And that there was a degree of institutional arrogance. It wasn't bad faith, it was just sort of blind stupidity that allowed them to do these things. And then ultimately, a lot of the sanction came from the fact that they tried to hide it after it happened. That they didn't come forward, they didn't explain what had happened, and they didn't try to cooperate with the court. Now, the next couple pages are sort of in there for you to peruse. It's about willfulness and the fact that there was no requirement of a smoking gun, mostly because the emails may never be recovered. Now, the impact on the case for everyone involved, both plaintiffs and defendants, was severely impacted. Just the practical impact of having to do this sanctions investigation in the last 3 months leading up to trial It was found out about 3 months before trial, and the actual final sanctions order was the week before trial after the jury had already been impaneled. And for practical effects, you have $1.2 million sanctions, negative press on the eve of trial, and the state ultimately settled for $50 million 2 days after that sanctions order came down. For the lawyer, and maybe personally for us, the impact was pretty immediate and pretty significant. The attorney was fired. The main AG, assistant AG that was handling the case, was fired the next day after the sanctions order. And he's currently being investigated by the Washington State Bar Association for violation of RPC 3.4. Not only is he being investigated, the grievance that have brought the claim against the attorney also asked for the Attorney General of the state of Washington to be investigated, as well as everyone else that was involved in the case. Whether that's actually going to happen is unclear. So the takeaway here, the lessons learned from the perspective of making sure that you uncover spoliation on the other side, issue expert discovery early, and really focus on making sure that you're diligent in getting whatever materials there are. If you're not getting something that you think should exist, and even if you're not getting things that may not exist, make sure you document that so down the road you can tell the judge, we asked for this, they didn't give it, and that the time difference between when they actually produce it and when you ask for it can be significant in sanctions. And then finally, to make sure you're not spoliating. Now, in this particular case, the experts are the ones that decided to delete all of this information, but the Assistant Attorney General was in the room when they made that decision. He was sitting there, he heard them say, yeah, we're going to delete all of our emails, and he didn't say anything. And that was his defense, that he didn't instruct them to do that, that one of the experts had said, oh, yeah, I do that all the time in my case, it's not a big deal. So pay attention to what your experts are doing, and you need to make the decisions. And then ultimately, if you're involved in spoliation, make sure to release it as soon as possible. Get behind it, or get in front of it rather, to be able to make sure you're not getting worse sanctions. And ultimately, all this comes down to what I said before. You have to understand what's happening. If you're going to have an interdisciplinary team that you don't normally have, think through the effects of what that's going to have on your expert discovery and how that's going to influence your ethics responsibility. Thank you.